Hi, Davi. How are you?
I'm fine. How are you?
Good to see you.
How is Delhi?
Delhi is very, very polluted. It's the worst place to live today. We're all living a slow poison death in Delhi. There's so much of pollution. It's amazing.
Why
450.
is it that this year it is worse actually now without this crop burning time?
I think it's just lack of political will more than anything else because we're all dying a slow poison death. Last
Uh,
night, the AQI was 451. So
mm.
we're still living in paradise, I must say.
Yeah, see, children and others must be having even a long-term effect of this.
Huge, huge, because all our lungs are getting impacted. We're trying
Yeah,
to go out the bare minimum, but then that's what things are. So, how are you? You seem to have lost a lot of weight. Are you okay?
I'm I'm okay.
Okay.
Yeah,
Okay, okay, okay.
okay.
So, how's work getting along? All good?
Good, good.
So, now DPDP has been formally, shall I say, implemented?
Yeah, so there is a greater interest in the corporate circle, so there is more traction. But of course, we are now into December. I hope by January things will go further. We are of course focusing on trainings, which from November we are doing the third training now actually.
Hmm.
November 1st and middle of November. Now again in the middle of December we are having one more training.
Okay, okay. That's nice. So, are people beginning to start moving around, or it's still now waking
Yeah,
up
yeah,
more?
yeah. There are companies already starting activities on compliance.
Okay. But most of the people are still saying, well, it's only the consent manager, everything else goes on till May 2027. So, we
True,
can.
true. 1.5 years time is there, but big companies they need as much time as possible. It is not possible for them to be ready fully, even
Correct.
in 6 to 8 months or at least 9 months.
Correct. Correct. Now I understand that. So let's see
Mm.
what happens. I might have to leave out of some time, but I'll be here till such time. I should be having an hearing. So
Yeah.
uh, then I may log out and join back again. This is going to go till 5 o'clock, right?
Yeah,
Yeah.
Pavanji. Just Kushbu is joining. I think she's finding it difficulties joining.
No
So,
problem. We are here.
yeah,
We're at your disposal.
no, it's our pleasure, Pavanji.
No, that's a good. I already see 108 participants here. I hope we are not yet in the. We are not yet into the final room, right?
Yeah,
Okay. Please, sir.
Navneet, should we start? Pawan wants to go early. Ah, hello?
so I think you were not in mute. Yeah,
1.88 ಅದು ನಿಮಗೆ ಬಂದಿರೋದ ರೀಫಂಡ್?
Awesome. I think we are already 10 minutes away on the session and things. Very good evening, everyone. Thank you so much for joining the interesting session. Along with you, I'm also here to learn from the leaders in terms of from the legal aspects. What are things just where we wanted to learn, and what are the actions, what are the impact which is going to create across the country, across the organization, as well as across the society. So if we take, from the DPDP standpoint, where it's been very, longer time we were waiting, like when we are going to start, whether it is a good time to start or something like that, right? It's been very long journey from 2017, where it has started like a fundamental rights of, the privacy. And then from this 2018, where we started in terms of the first data protection bill, it has been introduced. Then, of course, 2019, 2021, where we have a lot of, the iterations and, the challenges. But finally, on 2025, November 13, it got released as, act, and the rule is ready to get enforced on the across the country. With the respective timeline, of course, where we have two timelines. One is 12 months. What are the class which is applicable? Then we have 18 months, which is a full stringent enforcement across the country. So we have a series. The series we are starting with legal aspects. The series one, it's purely on the legal aspects. What are the things just we should look from the DPDP Act? Then down the line, just where we have a series with the CIO and CISO, then CTO. Like in terms of every one aspects, like what are the things just where we have to look, what are the aspect where we wanted to cover, right? That's like a key focus where we have, so that we know the essence of the layer, like from the legal standpoint, what are things we have to start, and then from there, how we have to move on that. So here we have a multiple, things will come into the picture, and specifically where we have a DPDP board, where which is going to govern this complete consent management. It's like overall an act from the end to end, including who has to penalize and what level, and what are the other things just where we wanted to get things done. And if you see overall 1 year, what are the classes? Of course, we will see, and then 18 months, what are the classes where we should look, and then what are the personal data? Whether this DPDP Act will be applicable only on the personal data or digital personal data, right? Of course, personal data play a very significant role, but if anything digitized, then that comes under part of our scope. So like anything, it's a collected in digital form, or maybe offline you have connected later, it is digitized, right? So those things will consider as part of the stuff. Then we have a three major the player. One is in terms of data principal, the data fiduciary, and the data processor, right? Data principal as we as an individual, what exactly we want to get. Like in GDPR, we call it as a data subject. And then, of course, data fiduciary, it's a data controller, and data processor, it's more of the the data processor who is processing the complete data point. Then just where we have applicability, this law DPDP Act 2023 applicable to whom? And this is it's applicable. The digital personal data is processed within India or maybe outside India, but they offers goods or services to individuals in India. Ultimately, if you have a residence of the Indian citizens, then absolutely you are all part of the scope to cover this complete the compliance. The very interesting aspect is where we have a consent and data principal rights, like what are the things just they can do that in terms of the access removal, or in terms of giving the consent, explicit consent, implicit consents, and then how we are going to manage the request for each and the every applications. Then there is a board where we have a role of the board. The board which contains all the laws, and then the roles and functions, and what are the enforcements, what exactly we wanted to to get things done, right? So all the objects it has been covered over there. And a very interesting aspect is, that's a penalty, right? Because that's what, if there's no penalty, there is no seriousness. So up to 250 CR INR, there is a penalty based on the impact and severity of the incident which has happened. So even the high level directions they have given, what kind of stuff, it starts from 50 crore to 150, 200, and then 250 crore from end to end. And within 72 hours, how we have to notify this respective, the incident, to whom, what, and what are the actions you have taken over that actually. Then another interesting factor is, in India, close to 42% of digital, the users are less than 18. Because if the age of 10 to 18 is the majority of the children, they use phone. But just a concern is, of course, their mother and the parents, the digital data. But however, the consumption is done directly by the kids. So below 18, how you're going to manage that thing's also like a bigger challenge is what we are going to do that. So with that approach, just I want to give a complete, the high level hints, right? That will give a what we are going to talk about it, and then to where we are going to start on that, right? So along with that, really, I wanted to start with, Navi. The biggest stuff is Navi is the giant in the market. I mean, specifically on the data privacy, it's a long way has started on its own and created the huge impact in the industry side. So Navi, really just I want to give just start with the initial, right? I mean, of course, where we are going to focus overall concern, purpose, and data principle rights and legal responsibility, cross-border data transfer, then overall enforcements, and then what are the liabilities and penalties. But very interestingly, where that's like how the AI profiling, automated decision making going to play, and then what are the laws which is going to the impact. Then it's overall breach notifications and then cybersecurity. And in India, from your standpoint, predominantly we use a SaaS product. So how the contracts and vendor management, that what risk it's going to manage, right? That is also a very significant discussion. We are going to have it in another the 1 hour time. So we want to start with the Navi. The initially, what are the biggest misconception organizations still have it about the DPDP Act? Because that's a challenges, right? The people will think it may not be applicable for me because I don't hold such a data. The fintech think like I hold this data, it's maybe applicable only for me, right? So I really love to hear from you, Navi, like in terms of what are the misconception and similarly how we can take it forward and which are the entity which is eligible and qualified to be part of the DPDP Act enforcement. Over to you, Navi. I think you're on mute.
Okay, sorry. Now, see, if you are looking at applicability, DPDPA does not distinguish between the government and non-government entities. All of them come under the provisions. The smaller or big, that distinction is also not there. In GDPR, you have some distinction, 250 employees or something like that. Here, there is no such distinction, which means that a big hospital as well as a small clinic, both of them come under DPDPA. In SBI as well as a cooperative bank come under this. So there is no exemption at present, at least, for any type of organization unless they are notified. Of course, there is a provision that certain classes of data fiduciaries can be notified to be exempt. We do not know how the government is going to make use of this provision. It is within their powers to tomorrow come back and use that particular section and give relief to SMEs or any other category of data fiduciaries. But as of now, we do not know, and we have to consider that everybody will be coming under this. That is one misconception, if at all it is there. Now, coming to the penalties, there are many people who think that this is a privacy protection law, so therefore the data principle should get some kind of a relief. And many people think that if 250 crores penalty is there, I should get 1%, 2% of that. But this law doesn't give any relief in financial terms to the data principle. Data principle can file a complaint based on which data protection board will decide on imposing penalties. Okay, the data principle will have to go back to Information Technology Act and claim whatever compensation he can claim there. It's not that he is not going to get compensation, but he will get it from a different statute. Similarly, one more major misconception is about data processors. Data processors are not directly liable under the penalty section. However, the data processor will act under a contract with the data fiduciary, and because of that, Information Technology Act tries to bring in a penalty of 25 lakhs if any contractual say failures are there. So they are going to be covered indirectly, and in fact that is the reason why we have proposed that we will have a compliance drive even for data processors, because they should not think that they are outside the provisions of DPDP Act. So these are some of the major things. There are many other misconceptions, particularly regarding consent manager. Many people think that I can set up a consent manager as part of my corporate entity. It is not going to work like that. Consent manager is a new kind of organization. As of now, there is no consent manager in India. The first consent manager will have to get himself registered with the Data Protection Board 1 year from today. Before that, they have to set up the platform, get themselves audited, and all these things are there. And there are a lot of uncertainties about how this consent manager business will run. So as of now, there is no consent manager. And consent manager cannot be set up by an organization, one of its division, maybe HR department or something cannot become a consent manager. This is a different entity which has to be a corporate entity with minimum 2 crores net worth and so on. So that is another misconception. So I think I will stop here. We'll come back to these things later. Navneet, back to Navneet.
Absolutely. Now, we just one more lead question. So, like, how about the PSU, public sector units, and all, how it has been covered? Earlier there was some exception, and
Exemption may be available only on notification. See, there is something called instrumentalities of the state, but even the instrumentalities of the state should be exempted by notification, and such notification can be given only in case of those organizations which are into national security and law enforcement and that kind of a thing. So virtually, public sector organizations are not going to be exempted from the law. They also have to follow the drill. Yeah.
amazing knowledge. Thank you so much on setting up the context. Hi, Kashfu, glad to have you. And I know that your schedule on the back-to-back, really just, along with Navi, really just I wanted to see a couple of our opening note, and specifically, how do you interpret, DPDP Act core intentions? Because, see, from India standpoint, no, we are not like the European or maybe the Western style, right? Like we don't hide anything as the private, and we don't ensure that it's a privacy. If you travel a bus at like 1 kilometer to 2 kilometers itself, we will disclose all the information to our neighbor, right? That's a relationship we maintain. So really, just I want to know whether this it's more business friendly, or it's a citizen centric, or it's a enforcement driven. Because sometimes the business also play very significant role, right? If the data processor is controlled by DPDP Act or Data Privacy Act, then that's like a more trust and confidence established in the global economic forum. So glad to hear your input, Kushbu. I think you are on mute. No, Kushbu, you still were on mute. Yeah, maybe later, rejoin. Pawanji, so maybe over to you, Pawanji, in couple of things, right? Since you have seen, I've been part of your, the global conference, and we're really, Kushbu, can you hear us? No, still we couldn't hear you. Your video is absolutely visible, but not audio. Maybe sometime Rejan may help with your audio. Just call Kushbu and then check it. Awesome. Meantime, Pawanji, just really want to know, since you have seen complete GDPR stuff, really just I want to understand how does the DPDP Act learn closer to the GDPR, or less, or more, or it's a fundamentally it's different in terms of the principle for the India? Because we have to see the culture also, right? I mean, we cannot, as rightly mentioned, we cannot go straightforward like in a very stringent way of regulations and then enforcements. So, like, just I want to have a little bit comparisons. So, when compared to the GDPR, are we more or less are equivalent to that?
Thank you, Navneethan, for those comments. First and foremost, when I look at it broadly, it does appear that the DPDP Act would seem to align with GDPR. A lot of people have the mistaken notion that the DPDP Act is an Indian equivalent of GDPR. I think there is some merit in that particular argument. Why? Because when I both look at the DPDP Act and the GDPR, both of them are emphasizing some fundamental issues. Issues like consent-based processing, issues like purpose limitation, data minimization, issues like rights of individuals, and issues like accountability and security obligations. But that's where the similarity ends. There's a lot of difference between the GDPR and the DPDP Act. Why? Because GDPR was drafted keeping in mind the European perspective, whereas the DPDP Act has actually been drafted keeping in mind the peculiar ground realities in India. So in terms of differences, I think the DPDP Act is substantially different from GDPR in several fundamental ways. Number one, in terms of scope of data covered, because GDPR covers all personal data in personal data filing systems, digital or manual. But when I look at the DPDP Act, it only covers digital personal data, which is data collected online or digitized. It does not really go that broad as the GDPR. Further, the legal basis for processing is different. In the GDPR, it provides for multiple lawful bases, but DPDP is all focused on consent-centric approach, tighter limits, and no alternates like legitimate interest and contractual necessity. Further, both of these instruments differ in terms of sensitive data and risk categories. Why? Because GDPR deals with, say, highly sensitive data, which is data for health, racial or ethnic origin, etc., with the extra safeguards. But when I look at the DPDP Act, it is only focusing on digital personal data on a uniform basis, without any separate sensitive category. Further, when I look at the scope of individual rights, the scope of individual rights is different in both these instruments. GDPR talks about broader rights like data portability, objection to automated decision-making, and restriction of processing. But when I look at the DPDP Act, I find that it does not explicitly grant some of these rights like right of data portability or objection to automated decision-making. Further, when I look at the regulatory structure and enforcement, I find that these are two distinctive animals, the GDPR and the DPDP. Because the GDPR is enforced by independent national authorities, which are coordinated by the European Data Protection Board. But as far as the DPDP Act is concerned, it's only going to be overseen by one single Data Protection Board of India, which is going to be appointed by the central government with broader governmental exemptions. Also, the entire issue of cross-border data flows is also beginning to be different. GDPR very tightly regulates transfers in terms of adequacy, decisions, and safeguards. But the DPDP Act actually allows transfer unless specifically restricted, leaving far more discretion to the Indian government. So there are some similarities, but there are a large number of distinctive differences. We need to appreciate that in India, no cut and paste legislation can actually work. And therefore, the lawmakers in their wisdom did not decide to do a cut and paste of GDPR and brought the DPDP Act. But from a practice standpoint, GDPR is far more strict and stringent than the DPDP. It's like the core, but the DPDP is good enough because it's actually embodying the GDPR-like privacy principles. But the beauty of the DPDP Act is that it adapts itself and these principles to India's legal, administrative, and economic context. So the ground realities are taken into consideration when they have come up with the DPDP Act. Therefore, there are slightly lighter compliance burdens for businesses and more state influence as far as enforcement is concerned. Yes, 250 crores does look big, but when I look at 4% of the total annual global turnover fines under the GDPR, they will actually translate to far more. Also, because from a practice standpoint, the DPDP Act is lacking certain basic GDPR features, and therefore it's only focusing on digital data. Therefore, it's far less expansive than the GDPR. And finally, the DPDP Act is a context-sensitive approach example because it actually introduces completely new and unique Indian constructs like significant data fiduciary, which set tiered obligations based on scale or impact, or provisions for deemed consent in certain cases. So all said and done, bottom line is there's a great leaning of the DPDP Act towards GDPR in spirit and core principles in terms of promoting informed consent, minimal data collection, rights for individuals, and accountability. But that's where the similarities end. There are huge fundamental differences in the different design choices between the GDPR and the DPDP. The DPDP is far more narrow in scope, far more has unique legal basis, different right sets, and is governed according to and is actually tailored according to India's legal and societal ground realities. So bottom line is DPDP, yes, influenced by GDPR, but it's not a full replica. It's a hybrid regulatory approach that India has adopted, keeping in mind Indian unique ground realities. Thanks.
Awesome, Pawanji. I think you highlighted just a very interesting statement, societal ground reality, right? I mean, that's play a very significant role. As initially, just I opened the note, it's like based on our culture, like what exactly it is initially it's required. That's what it is. It's a purely on the digital, the data, right? It's not on the anything on the offline. So initially we want to start with that, and then down the line, just where we wanted to move ahead. And I think we have a 23 rules, and down the line, I think as and when we keep improve and then keep enhancing, it will get evolved, and then additional tool get added. I believe that's the expectation. Awesome, Pawanji. I think Kushbu is back.
Hi.
Hi. Thanks, Kushbu.
I'm so sorry.
They're absolutely fine. Always, sometimes it happens. Just we heard from Navi as well as Pawanji on both aspects, like in terms of the opening note. Really love to hear from you how we interpret the DPDP Act core intentions, and he had given the tone like in terms of societal ground reality for that it's set up. But however, I wanted to see from your aspects specifically whether it is a business friendly, because as Navi had mentioned, this is applicable for the government as well as the startups. Irrespective of you were the 5 people or the 500 people or 5,000 people, you should be abide by the the law, right? So really, just I want to hear from you, like it's a business friendly or citizen centric, or really it's on the authority side, like enforcement driven.
Okay. Okay, so let's start with one. That forget everything else. You have an enterprise, I have an organization, Pavanji here runs an organization, or there are everybody who's running an organization here, some or part of an organization. All of us are a data principal to at least minimum of 100 organizations. And that's where you should start thinking not as an organization, but first and foremost as a data principal. Because when I say think as a data principal, you're living in the age of technology. And when I talk about internet and technology, the way information travels and shares and how it can be utilized and misutilized, and when it comes to understanding what's happening and how things are traveling is something which is very opaque, or I would say it creates an absolute black box. And that's where the problem started coming in. Think of the part that Navnitam, I can't come into your house and think that, oh, this is a beautiful painting. I think it will look very pretty in my house, and quietly just take it. Or I cannot think of that, oh, this wall is empty. Let me bring in some vase in front of this. It will look very pretty. And can I come and keep it in your house? Or can I just tomorrow go to Pavanji's house and just chill there? That, oh, I want to spend maybe some time, I can chill there. You can't do this, right? Not at least without asking you, without taking your consent. The same thing comes on the world of internet, that what they're trying to tell you is the intent of the law is to bring in that absolute clarity over there. Once you bring in that transparency is where we will start bringing in accountability. Accountability was a major issue in the internet world, and this is where the law is talking about that what you have got a right to privacy. With that right to privacy comes certain rights. Now if those rights are not been implemented, the privacy aspect will be negated. What that would be? Something like a consent, something like an access, that what my data is lying with you, let me know about it. I have given you the consent, but tomorrow I want to recall that consent. Let me have that ownership to it. Also, I have my data with you, but I want to exercise right to erasure because I do not relate with it, or maybe I don't want to continue with it. I don't want that data lying. The same thing, the next that comes is maybe there is something I want to correct and you should be able to correct it. Or if you've taken my data, I'm absolutely giving you anything and everything which you want to take from me, despite it has no relationship with the services that you're providing me. I'm happy to give you that. But keep my data secure, because that data not being secure goes in the hands of people, which can utilized in scams, or it can be for giving me information or tracking me, or getting those scam calls or those unverified calls that, new schemes coming up, new policy coming up, why don't you buy it? Now for all these things is where the data is thinking that if you think of the law, the DPDP Act is practically for people. It is people centric. It is keeping people in mind. And that's where, coming from your question, that it doesn't differentiate between whether you're a small company or you're a mid-sized company or you're a large enterprise. Whether you deal with 100 people, you deal with 1,000, or you deal with crores of data principals. Whether your turnover is A, or your turnover is A plus A, or your turnover is A plus into Z. It says you're taking data which is personally identifiable to the person, which is in a digital form. The act is applicable on you. The penalty is equivalent to all of you. It doesn't differentiate on the penalty depending on the turnover that you have or the number of people that you have. The only thing where it differentiates is it says that if you're a significant data fiduciary, extra layer of obligations lies on you. But when it comes to penalties, when it comes to those basic rights which are guaranteed under the law, has to be complied by everybody. Now, when we understand that this is people centric, then understands that as companies also it is very nice, because when you talk about privacy, you have to understand that there is also an element of security, and security and privacy practically are two sides of the coin. If you have taken care of the privacy, practically you have taken care of 80% of the security as well. If you think in that manner, if you understand how many data are entering in your organization, why are you taking that data? Is there an element of data minimization, need to know basis aspect, masking, encryption aspect of it? Then which all entities are you sharing that data with? In internal departments, where are these data lying? What's happening? If you take care of this entire aspect, you have made that organization pretty much understandable, clean, so that that security aspect, where, how much security where to be kept in place. So I would again say, and if you think of applicability, I think it is applicable on everybody, even when it comes to government entity, till the time it is not been notified for certain aspects. The exemptions are also, if you see the carve-outs which are given in the rules, the carve-outs are also very specific when it comes to, so that the act doesn't become non-applicable when it comes to in practicality if you have to implement the law. Like for example, the carve-outs when it comes to children data, the carve-outs which are being given that while education institutions, while those they are having CCTV cameras because of the monitoring to be given to the children, to the parents. I think those are the carve-outs, but there also they have got limitations to that carve-outs. So I think the exceptions, the carve-outs are also made in a manner to make this act applicable without any hindrances. And I would say the act is practically an extension to that right to privacy, which was guaranteed by the guaranteed under the Constitution of Article 21, how it can be implemented and what are the obligations, and in the absence, what are the penalties that can be imposed. And if you just convert that, it will become a rule book for every enterprise as to how do you comply with it. This is my basic understanding. Right to access, you need to understand what you have to do for it. Erasure, what you have to do for it. So it just becomes your rule book. Once you have that privacy culture in your organization, I think it is not that difficult as it feels. Over to you, Navneeta.
Awesome. Khushbu. I think you have taken a lot of analogy also. So I think that helps a lot in terms of interesting point. Really, just I wanted to understand from the legal standpoint, what are the 5 immediate actions every company has to start looking? Because it's like there's a lot of confusion also is happening, right? Earlier also we were having like this is a responsibility of data privacy officer or the legal or the compliance or CISO, CIO. It's like a many stuff, right? But really, just I want to see since now the rule is out. Really, we want to understand the first 5 immediate from the legal standpoint. What exactly we have to look on, because even though we have 10 more months, but it's a good to have from the legal standpoint what are things needs to be looked on.
Okay. Number one, when you talk about legal, have your consent redrafted, have your cookies redrafted, not just for the sake of it. Don't make it difficult that it becomes difficult for lawyers also to understand, but bring in that clarity, bring in that understanding. Number one. Number two, that you have to start doing that. I say that you should start understanding the entire flow of your data, and then make sure of that part that wherever you're sharing that data with any third party vendor, have your contracts amended. Have one data protection addendum which is applicable on everybody. You can have 2 layers of it. One can be for the data fiduciary. The second can be the data processor which is attached to you. Apart from this, I would say this would be your one document for each and every third party vendor attached to you, but you need to amend all the contracts, and those contracts have to have a clarity as to what permissions are you granting them, what are their obligations,
including existing contract, right?
Absolutely. All your existing contract, you need to make if I have to give you a to-do list, make a list of all of it. Why this third party vendor is being shared this much information? Is it related to the services that it is offering you? Are you asking them? Can you make them? Is it just process driven, or they are also a data fiduciary? They're going to utilize that data for some other purpose. Then you understand what all clauses you have to put across for them. Am I audible? Yeah. So make those list of third-party vendors, then you understand what you have to curtail, and then start having amendments to those contracts. That's very important. And at the same time, have one standard data protection addendum for your organization for all your third-party vendors, which can be signed. This would be your number 2. Number 3 would be that you start understanding the implementing the aspect of need to know basis, that let that data be with exposure to the people, as much data where it is required for them. Number 4, you need to have a privacy governance structure in your organization, because you're talking about tomorrow when you start getting a request from data principal, who would be responsible for what, who will do what, where any changes have to come, which department has to take care of. Even if you have a DPO and a team of DPO, you need to have different people from different organizations. You need to have representative from each of your department to be part of it, to understand. You need to start training part of it. You need to make changes in the internal policy, which is compulsory for each and every employee of you to follow, because at last they are representing you as an organization. Anything done by them will be something which a price a company has to pay. So you make sure that your front, where the data, the touch point comes in, the entry points, all those people are sanitized. And if you can bring in technology over there, that there is very less scope for those people to do, you will have at least a better scenario into it. And I think apart from all these things, when it comes to having also the aspect of having systems in place as to which all jurisdiction are you into. Are you just in India? You are in European nations, you are in Australia, you are in some other country. You need to understand laws of all those things. You need to then understand which all regulators of which country will be the applicable part of it. What are the reporting mechanisms? In what scenario you have to report whom? This also has to be done right now. It cannot be that, oh, something has happened. Because if you'll see, GDPR says that if the breach has happened, external breach attack, then is where it happens. India says, even if your employee, let's say, has shared the data with a party where it should have not been shared, even that counts as an incident that can happen, and DPDP clause can be attracted. So you need to understand who do you have to report, and how much timeline and what data has to be reported and what has to be done across. And if you're just in India, then what all regulators, apart from DPDP board, data protection board, which all regulator are the one where you have to do it. Apart from that, if you're in different countries, then what are the obligations over there? I think this is something which you have to have systems in place internally. That's where if that internal process are set, you can make sure that without any lag, without any difficulty, you can start implementing this entire process smoothly. I mean, there are more, but I'm just thinking of the time and stopping
No,
here.
awesome. No. It's absolutely. Maybe the later stage, I can get you a few more, the checklist. But thank you so much for, the Kushbu. Specifically, you touched on the consent data flow and specifically on the contract with the third party and privacy governance and the monitoring both entry and exit. Thank you so much for that. Pawanji, since she has touched upon in terms of the data flow and then consent, really, just I want to hear from a couple of other aspects since you have seen on the global laws and the privacy stuff. How strict is the DPDP Act requirement? Like you have given, it's like a societal ground reality we have formed in terms of first level of DPDP Act. So really, just I want to understand the notice and consent, right? Specifically, if you want to talk about in terms of educated, well-educated, and tier 1, tier 2, tier 3, right? In all the aspects, just where we have it. So really, we wanted to see that what qualifies the valid consent or implied or bundled consents legally safe under the DPDP Act. So we're glad to hear from you. And specifically, once you're finishing, really, I wanted to hear from for the children's also how it has been taken care for the notice and consents.
Thank you, Navneet. If I can say that DPDP is the pyramid, then the foundation pillars of the pyramid are notice and consent. And first notice, consent thereafter. You can't have consent first and notice thereafter. So DPDP Act very clearly says, the moment you're a data fiduciary, you must present a notice either before or at the time the consent is sought. The notice must be clear in plain language, even in local language if required. It must be itemizing the specific personal data that's being collected. It must specify why data is being processed and must inform the data principal or the individual on how to withdraw consent and how to seek the redress per se. Now, these requirements by and large are mirroring what the GDPR requirements are there, but it's far more streamlined because it does not mandate as many disclosures as the GDPR. Now, there has to be a legal basis for processing. I can't wake up one day and say, look, I've decided today to collect data, so I'm collecting data. Sorry. You'll have to have legal basis. Data can only be processed after valid consent is obtained, unless it is legitimately used without consent, which, for example, could be voluntary data shared by the principal, governmental services, emergencies, legal obligations. The question comes up for consideration is, what is valid consent? Now, consent under the DPDP Act must have at least 6 distinctive elements. Number 1, it must be free, that it should be given without force and coercion. Number 2, it must be specific, which is tied down to certain defined purposes. Number 3, it must be informed. The data principal must understand what he or she is agreeing to. Number 4, it must be unconditional. It should not be contingent on the unrelated conditions. Number 5, it should be unambiguous. It should clearly indicate the agreement to processing. And number 6, it should also lead to affirmative action. For example, maybe you're ticking a box or clicking on I agree. Just a passive or silent action, I think, won't really count. Your explicit affirmative action is necessary to show and signal agreement. For example, if I check an unchecked I agree box, that's consent. If I am clicking a labeled accept button, that's consent. If I'm submitting a signed consent form, that's consent. But how about a pre-ticked silent box? Is that a consent? No, that's not a consent. How about buried terms in long legal contracts? That's not consent. How about consent that's forced to and coerced upon the data principal? For example, you agree to all or lose the service. These are going to be invalid. Further, the DPDP Act does not really recognize implicit, implied, or bundled consent as valid. Why? Because the consent has to be crystal clear, free, and ambiguous. It must be affirmative and purpose specific, which effectively rules out most forms of implied or bundled consent. The next question is, how about consent for child data? For that, verifiable parental consent is necessary. Children are people, any person who's below the age of 18, as per the Indian Majority Act. Now, the law says I'll require verifiable consent from a parent or a lawful guardian before processing their specific personal data. So, what does that mean? That means that the companies must first verify the age and then ensure that the consent is genuinely obtained from a parent or guardian. The consent, again, from the parent or guardian of the child must be free, informed, specific, unambiguous, and with clear affirmative action. Of course, there are going to be some exemptions that are going to be given for, say, safety critical services, which we'll have to wait and watch. But then, for children data, there's some complete restrictions. You cannot look at behavioral tracking, profiling, or targeted advertising directed at children. And you cannot, as a data fiduciary, process data that's likely to harm a child's well-being. That's a very, very broad concept, but that could be coming up in this way. Another way is the Indian DPDP Act does not make a distinction between digital personal data and sensitive data. So there are going to be practical compliance demands, which will say, guys, you'll have to get more clarity from the government. Maybe the government needs to clarify by more rules and regulations. How about data fiduciaries treating, say, the specific sensitive personal data with far more heightened care and security? Because whether it's sensitive or not, it prejudicially impacts the legal interests of the concerned data principal. But I think even for sensitive data, the best thumb rule principle for data fiduciaries will be, please come up with explicit, documented, and unambiguous consent before you can start your processing. And finally, your content, the consent withdrawal and management connected issues must be clearly defined. Individuals under the DPDP Act, being data principals, have the right to withdraw consent at any point of time. That means the processing must stop unless another lawful ground is existing. Further, the withdrawal of consent needs to be as easy as the giving of consent. So the DPDP Act has stipulated the concept of consent manager, entities that's going to help individuals give, manage, and withdraw consent, though these functionaries are also going to be subject to regulatory frameworks. And with effect from the notification of 13th of November 2025, by 13th of November 2026, all organizations will have to have in place the consent manager. So thumb rule is very, very clear. You do not comply with the provisions of the law, the Damocles sword of 250 crore rupees comes in action straight away, which means if you have maintained consent or got consent, but the consent is not unambiguous, not unconditional, then again, it's a violation. And that being so, your exposure to 250 crores is very much on. Bottom line is companies, whether they are data principals, they are data fiduciaries or data processors, will have to come up with a consent checklist as to what is permissible versus what is not permissible that can broadly cover most of the predictable scenarios as you move forward, and inform all the employees and the staff of the company is concerned. Look, because if my staff of me as a data fiduciary commits a violation, the law presumes I commit a violation. The moment I commit a violation, then I, as a company or data fiduciary, become exposed to damages by way of fine up to 250 crore rupees. And mind you, I have no nirvana, because once a fine is given upon me, I can argue and say, sir, I don't have the money. But the law says, no problem. You don't have the money, not an issue. We consider this as areas of land revenue. Why? Because these monies are payable to the government of India in the form of payment to Consolidated Fund of India. You don't pay the government, no problem. The government will create a file. The government will then attach your assets of your company. The government will have the right to sell those assets. And if that amount is still not sufficient, then the next level is it's going to go towards the level of attachment of the concerned assets of the concerned top management. So it's going to open up a Pandora's box. Therefore, no amount of experimentation is going to help companies. Ensuring due diligence compliance with parameters of consent and notice will be crucial as they move forward. Thanks.
No, amazing, Pavanji. I think a little bit statement really scared many of the people. The people are thinking, yeah, if it is like 250 crore, and my revenue itself it is a 1 crore, then 250 crore from where they are going to collect it. It's not feasible, right? But just you have told, as a government, they make the way to get the things like including, taking your assets and then other personal stuff, right? That also may open in the bigger aspects. Amazing, Pavanji. Really, just now we just a few more interesting, the follow-up things from the Pavan as well as the Khushbu. Right? Since she had mentioned from the legal standpoint what exactly we wanted to have it. So if you take a SEBI or maybe RBI regulated stuff, what exactly happening is now there is a certain auditor and there is a 6 months once quarterly governance. It's based on the regulated entity or maybe yearly governance. Like there is a certain auditor, they come into the audit and they ensure that things are taken care of, right? So really just we want how the data protection board is governing or ensuring this control. We can't wait till incident has happened, right? I mean, if there is no incident, doesn't mean they are completely comply with all the requirement. So what are the minimum documentations like the respective company needs to define, like during audit or during investigation, or to ensure the compliance, by the board or any other audit by the data protection board?
See, to start with, every company needs to have a risk assessment done, and that will be the starting document. Okay. Now, based on the risk assessment, you try to implement whatever compliance is required. Now, if you look at a data breach scenario, you need to have an incident management system. And that incident management system, if it captures any potential, you can say, breach, then it will escalate into an inquiry by the Data Protection Board, and it may go into the penalty situation. Documentation basically will be to showcase what efforts the company has taken to be compliant. So training of its employees will be one of the important aspects. Then having appropriate documentation, what can be the information security policy, the privacy consents requests for different purposes. We normally recommend every company to first start with a inventory of processes similar to ROPA in GDPR, because without identifying where personal data is being processed in a company, you do not know what kind of privacy notice you have to send, because each process has got a purpose and that purpose requires certain data elements, and you have to have a privacy notice aligned to the requirement of the data elements. And again, the purpose and the process determines the data retention, and who in the company will be having data access. So everything depends upon the process. So one of the important documents which the organization needs to have is the ROPA. Then for consent, of course, there has to be a consent management system which starts from the issue of privacy notices, collecting back the consents, and where consents are not there, how to handle that, verifiable consent. This whole gamut of consent has to be a system. And when you are talking of minors and also nomination, there are also other complications like the minor becomes a major one day. So at that time, the parental consent has to be switched back to the consent of this erstwhile minor. So there has to be a process for that. And grievance redressal has to be documented. Nomination requires a system where you identify the possible report of a data principal having deceased and then identifying the nominee and so on. So a documentation of policies for each of these situations is something which an organization should start building now. Once you have the policies, then you can ask your technology team to build technology solutions. Say, they will have to follow the policies, and then of course whoever writes the policies can always test and see whether the technology is able to support the policies. So these are some of the things which I feel is essential immediately: risk assessment, compliance by design, documentation, consent management system, incident management, training, and so on. Okay, so these are the immediate requirements.
Awesome, Navi. It's like a few more follow-up questions. Do you think like a data protection board may release a minimum checklist for the maybe lower level organization or the enterprise, or maybe they're based on the sector specific, or maybe we have to assume from the rule because it's like a qualitative. It should not be qualitative, right? It should be quantitative.
Say, one of the hallmarks of this particular law is they have called you a data fiduciary. So you are the fiduciary who has to decide what is good for the data principle, and you have to generate your own systems. In fact, we should not expect a checklist from the Data Protection Board. Data Protection Board is unlikely to take any great policy decisions. They will be acting more on conducting inquiry and imposing penalties. Most of the policy decisions will be done by the ministry directly. And even to know whether you are a significant data fiduciary or not, I am not sure whether the government is going to come up with a checklist and say, so such and such a company is a significant data fiduciary. They will simply say, you have to make your own assessment whether you are a significant data fiduciary. If so, you decide whether you will have a DPO or something like that. My role is that when things go wrong, when I do an audit, at that time I will ask you, why did you not have a DPO? Then at that time, if you say, I thought I was not a significant data fiduciary, I will perhaps question on that. So this is the principle which the law represents. There is more of, say, discretion given to the data fiduciary. And the data fiduciary, to that extent, has got more responsibility. In fact, it is good for people like us because these data fiduciaries have to come back to consultants to find out, where am I today? Okay, am I a significant data fiduciary? Then we may have to look at the volume of data processed is easier to find out, but the sensitivity of the data being processed is a subjective thing. Okay, many times you do not know how to assign a sensitivity score to a particular kind of data. But that is where the organization needs to get expert opinion and then take a decision. Yes, I think I am on the border of significant data fiduciary and I have to take some precautions. So of course, I support the government in this because the Supreme Court itself, in its Puttaswamy judgment, did not take the responsibility to define what is privacy. So they said privacy is a fundamental right, you protect it. But they did not give a checklist of what is privacy. They just kept it vague. Maybe it is not possible to define privacy. Now, government, therefore, did not go for a privacy act, where they could have, if they had gone in for a Privacy Protection Act, the first clause would have been what is privacy in the definition. So they did not want to do that, and they said, I will call you a data fiduciary. Please look at the circumstances and decide what is good for protecting what is called the right to privacy of an individual. Same thing they have extended now, and they say that you decide what is, whether you are a significant data fiduciary, you decide what is good for the data principle. Therefore, I don't think checklist instructions can be obtained from the ministry. At best, if you have got a doubt and if you ask them a clarification, if they give a reply, you should be happy. But that if I am the government, I would say that I would not like to put my stamp on anything, because tomorrow courts may hold that what you have decided is not correct. So ultimate decision will have to be with the court. Until such time, others will do what they think is best in good faith, and jurisprudence prevails. But exacting, ultimately, perhaps some court will come and say what you thought was not correct. Then neither the data fiduciary nor the government can dispute that. I think that is the situation. More responsibility, more discretion, but that has got its own, cutting edge problem. Yeah.
No, absolutely, Ravi. I mean, you managed on both the side, right? I mean, you supported government and you supported, the entity also. So here the problem comes is how do you quantify such the bigger challenges, right? When we coming to the compliance or the non-compliance, until unless there is an incident.
That's why documentation is very, very important. See, the documentation on applicability, documentation on why this is sensitive, not sensitive. So, of course, it's a techno-legal compliance. So, documentation is essential. Because you are the data fiduciary, even if you take a wrong decision, I need to have a documentation of why I took a particular decision. Because tomorrow when there is an inquiry, I have to tell them that these are the considerations under which I took this particular stand, which may be disputed later on, but at least that will reduce my penalty. Okay.
Absolutely. Thanks, Naviji. Pavanji, just the few more interesting stuff, right? When we are talking about digital data, now the entire world is evolving on the AI. When we take a digital data, of course, the AI need all the digital data standpoint, right? And because I not find any specific classes, really just we wanted to see if any data processor which has a AI component or any data which has been processed for the AI purpose or training the data sets, like how you're going to handle. So like we have any explicit rule or explicit act of, how you're going to handle, because we don't have any dedicative, like a European AI Act, right? Similarly, we don't have anything in India. So how you're going to, the balance, glad to hear, because all the organization now we are using, the AI, whether it is in-house or maybe the third party one. Glad to hear your input, Pavanji.
When the DPDP Act was passed in 2023, 11th of August, life was different. Today, end of 2025, life is completely different. And the DPDP Act is already obsolete in the context of AI. Why? Because it does not mention anything about AI. How about if AI is the data fiduciary? Because AI makes a decision whether the personal data of the data principal is going to be processed when and how and where. If that is the case, those aspects are still not covered under the Act per se. So first and foremost, let's get this very clear. No specific AI-specific rules under the Act. But the beauty is that the DPDP Act is a technology-neutral law. It basically is regulating processing of digital personal data. Does not have explicit reference to AI, but ultimately AI-generated data is also digital data. And therefore, it actually means that the law would still be able to cover aspects of personal data used by AI systems. Therefore, any such data processing must necessarily still comply with the core principles like notice, consent, purpose limitation, minimality, and security. However, If you're trying to look for something specifically on AI, you don't find that under the DPDP Act or extensively under the DPDP rules. Another issue is what happens if the automated decision and profiling is done by AI, in which case the data principal does not have any mandated right to contest. He finds that he does not even have a right to an algorithmic transparency requirement. And of course, the law does not even talk of a bias or a fairness audit. So all these are things which are going to put the data principal in a slightly weaker wicket when his data is being dealt, processed, or handled with by AI in its capacity, either as a data fiduciary or as a data processor. But I think some broad general protections would still apply. We would still, the law would still want the processing of AI to be fair and reasonable. We still would expect that the requirements of consent and transparency would be followed. And what's going to really be important is what kind of new directions and guidelines do we get between now and November 2026 in terms of the applicability of the DPDP rules and the DPDP Act to AI. So there's a huge gap currently. Why? Because the Indian law does not mandate any explanations of AI decisions like GDPR does. Well, the entire issue of algorithmic impact assessments of fairness protections are absent in the Indian context under the DPDP Act in the context of AI. And finally, there is no right to appeal. Automated decisions taken by AI that would significantly enhance or prejudicially impact the legal interests of the users per se. So bottom line is, if you're using AI, you can relax and say the DPDP Act does not cover explicit constraints or safeguards which are targeted specifically at AI-based profiling or automated decision-making, but then it's too early to celebrate. Why? Because the still broad data protection principles like lawful, fair processing and consent to any system will still be applicable in the context of AI system. So it'll be good if we can get more clarity, but as a matter of abundant precaution, even for those data principals or data processors who are using AI, please remember AI is being used for and on of your behalf. So you are governed by the principal agent relationship principle, which means that even if AI is your agent, you as a principal, being in your capacity either as a data fiduciary or as a data processor, will still continue to be liable. So if you don't want this Damocles sword of 50 crores or 250 crores hanging on your head in the context of AI, it still will be better that your AI connected operations are also ensuring compliance with the provisions of the DPDP Act. Thank you. Navneethan, if you would mind, I'd have to rush out. If it's possible, can I sign out now?
Yeah, Pavanji, just one more interesting question. So maybe from that, just I wanted to leave you. So it's a specific things is if you take a GDPR where we have a 2% and 4% of the the revenue, there is a the penalty, just they have kept it right. But in India, just if you see the blindly, just we made it like a 50 crore to 250 crore. It's not connected to the revenue, right? Because sometimes it's a smaller organization. As rightly mentioned, so straight away, if there is a default, it's like 100 crore. The revenue itself, it's maybe it's a close to 5 crore or less than 100 crore. It's a bigger, the impact. If it is connected to the revenue, then it makes sense, right? What's the rationale behind, Pavanji? Just really glad to hear that input from you.
I think the rationale was very simple. The Indians' ecosystem was not familiar with that 4% or 8% of the total turnover exercise. So the lawmakers felt that it's best if in India, crystal clear figures are stipulated under the law. So they came up with this minimum figure of 50 crores and then maximum figure of 250 crores because that's something that's understandable. A 4% or an 8% of your total global turnover was something that could be very, very objective, very subjective, and that could be interpreted either way by various stakeholders, including the Data Protection Board. Therefore, they felt in India, this is the only unique law which does not specify an offense, no criminal liability. That's why the lawmakers made it absolutely clear that we are not giving you any offenses. You won't be sent to jail, but then we are hitting you where it hurts the most. Because in Indian ecosystem, your pocket is most sensitive. So they said, you don't comply, I'm going to straddle you with minimum fine of 50 crore rupees. Yes, from 50 crores to 250 crores, the discretion will be up to the Data Protection Board, how much fine has to be given to you. But the maximum capping of the fine has been put at 250 crores, which I think is even too vast, too large a quantum from the perspective of the entire current Indian digital business setup. So people are still beginning to wake up. A lot of people are saying this is a classical case of the lion is coming, and the story ended that the lion never came. Now, in this case, you can say lion is coming, and sit back and relax. But the lion has already arrived. Once the law stipulates minimum 50 crores, maximum to 50 crores, the Data Protection Board of India has no discretion. All it needs to do is to find out, have you gone ahead and complied with the provisions of the DPDP Act or not? If you're non-compliant, your entry ticket starts at 50 crore rupees. So once there's the finding by the Data Protection Board, you cannot escape less than 50 crore rupees. It's like the minimum ticket for going inside a cinema hall to attend a movie. But this is going to be a very costly movie. So therefore, I will encourage all stakeholders, please go ahead and do your documented compliances and your appropriate documentation to show your prima facie broad compliances with the DPDP Act and the DPDP rules. This is a law that's not to be played with. You try playing with law and you will repent for a lifetime. I can pretty much say you in writing. Yes, you may be lucky. You contravene this law. Maybe there's no complaint against you. But what is the guarantee that there will never be a complaint against you? There's no minimum restrictions of limitation that the complaint against you must come immediately now. Since in this case, the government will be deprived of legitimate revenues, the government can initiate action at any point of time. Of course, at least for the first 7 years, the Damocles sword is going to be hanging on your head. So is it worth putting that Damocles sword on your head, or is it worth spending some money and having sleepful, restful nights without any disturbance? The choices are yours. I don't think the DPDP Act is an act to be messed up with. You try messing up with this once, and this law promises that we'll mess up your entire future, mess up your entire corporate operations and your business prospects, business opportunities, current and prospective, for all times to come. That's a broad message I see on the horizon. Therefore, the need for giving as much respect, as much regard, and as much compliance to the DPDP Act, the better it will be.
Awesome, Pawanji. I mean, to really be scared, I think everybody started to look on to a very serious note, like what exactly we have to have a look on. Even though you have given the initial ticket and the top tickets, and what are the action items, just we have to do it. Of course, we'll have a subsequent discussion.
Sure, but thank you, Navi.
Glad to have you.
Thank you, Navi. Thank you. Take care. Bye-bye.
Yeah, we'll connect. Kushmaji, thanks, Pawanji.
Thank you.
Kushmaji, just, as Pawan and then Vijay left a couple of things, really just I wanted to see from the vendor standpoint, right? I mean, if you see the India, the majority of the business, it's evolving on the SaaS. Really, I don't hold, any data, right? It's somebody else hold, my data. That's the way it's hosted. Whether it's a platform as a services or infrastructure services, absolutely, I don't hold it. It's with, somebody else. So really, just I want to know, like, maybe if I'm a SaaS provider or I'm the SaaS consumption, there's a company, what are things which needs to be, taken care? That's the first one. Second one, maybe if I'm making the contract, with a SaaS provider, what are the minimum class I should have it as part of my, the contract class with the third party, whether it's a service provider or maybe the service, the receiver. And third one is really, I want to know what is the legal liability. If I don't abide by the, respective, the contract established, what is the legal liability for the vendor? Because they might not be the data processor, right? And really just I wanted to see that aspect also. Over to you, Krishna.
Okay, so I'll just make it a little simpler. I like making things very simple. So pardon me if I go a little away from your direct question. Let's understand what do you mean by data processor and data fiduciary. Data processor is somebody who you say that you have to do this for me. If he performs whatever you are asking him to perform on your behalf, That can be your SaaS part of it. That I'm just asking you to perform this on my behalf. Practically, you're not doing anything beyond that. You can't process that data beyond what I am asking you to do it. You cannot utilize that data for any other purpose. You cannot contact them without anything. You cannot keep that data and utilize it for anything and share it with anybody else. So practically, I am just putting you to do what is required to do as an extended arm. That means you're a data processor for me. The moment you go beyond that data processor, you use that data, you process that data for something else, you can utilize it for some other purpose, you can process and have more combinations to it, and then can come out, churn out with some research or something else or some more data, more aspect into it, is where you become a data fiduciary. Now, any entity that you are, any vendor that comes in place where you are sharing, and he's a processor for you. That means the SaaS part of it. You make it very clear via your contracts that this is what you can do and this is what you are absolutely cannot do. And if you do this, practically that would be an infringement of the contract, the clauses of the contract, and this much penalty I, as an entity, can impose on you. Plus, it can invite termination clause. Plus, apart from terminations, the penalty that you can impose. And let's say tomorrow, because it has gone beyond. Now, let's say a request of a data principal comes that I need to exercise my right to erasure, or I need to exercise my right to amend. But you don't know only that the processor has used that data. That hence you cannot comply with that completely, is where you will say the penalty that can be imposed on me by the data protection board for not complying with those obligations, I will transfer that liability to you. Because in the eyes of the law, I am the data fiduciary. I am the one responsible to the data principal and data protection board. After I being responsible is while I'll add more people who are the one who are responsible for it. For that, I need to have a contract in place and I need to have those things very clearly mentioned in the contracts. Please do not go for copy pasting of a contract. Just because you've got it from somebody, just because you're using it from very long, just because it has been continuing, the name says that this is the contract. No. It cannot work like that. It has to rework. You will have to go deep dive into what is the need of that vendor and what are they doing with it, and for that how much is the sharing is happening and what can they do or not, and in the event of any kind of infringement is what penalty you can impose, and the termination clause when it will be invoked, and how will you transfer the liability that will be imposed by the data protection board, which is imposed on you. You will transfer it to them. I think the last part where Pavanji was talking about hefty penalties, I think that's where you will have to bring in place that you have to understand this very clearly. Otherwise, you can be literally out of business just by non-compliance of certain obligations under the Act, and that also not of a fault of your own. Now, as a company, as a SaaS company, you will also have to make sure that you put it in your contract that what exactly are you doing it, and have those systems in your place in your organization that this is what I am obligated. I will not go beyond this, and have those systems in your organization that after that you delete the data, you don't have exposure to the data, you don't do this, and make sure that your people in your organization also abide and understand those aspects, those clauses. Without that, it will be impossible for you to run through. So you need to have not one, two, but one major clause of data protection clauses, which will have 10 or 15 subclauses into it. You need to have an understanding of what data usage or permissions you're granting them, and it can have another 5-7 subclauses into it, because if let's say they're doing this, they are bound to get an exposure to that, but they cannot do anything with it. Or whether they can do anything after that, what can they do? Let's say an example of it, that I'm a bank and I have got a tie-up with a hotel. Now, while issuing a credit card to you, I said I'm also offering you a membership, or I'm offering you, there is an offer of 2 nights with this hotel with a partnership of ours. I take your permission that I'm going to share it with that hotel as well, with that card. Now, that hotel thinks that now that I have got Khushbu Jain, she has used her voucher for those 2 nights. Now, I still have data that I've got Khushbu Jain, and like Khushbu Jain, I've got 20 more people or 2,000 more people. I want to now send them details as in promotional schemes or my own offering or some better membership cards or something else. You will contact me, but that permission is not being taken by the bank. That's where I will take very clearly, while my contract is done with that hotel, that this is my permission is only restricted to that. The moment you contact them further is where you take a separate, independent, explicit consent from that person. If you don't do it, you are in contravention of the contract. I mean, I can go as much as when it comes to contracts,
No,
but
no,
I would just say
absolutely,
that it is very
Absolutely.
important that you cannot now continue with a copy paste or going with the archaic whatever the contracts were there. You have to amend your contract, and I would say that should be done as on yesterday, and it
Absolutely,
has to be
Pushpamani.
tactfully done.
Absolutely. Sometime I'll get impact the class also at a high level. What are the classes minimum, which is required for the SaaS provider. So that also will be useful. Maybe from that we can take it forward. Awesome, Kushbu. Naviji, just in following with it, actually, I mean, she has mentioned for the SaaS as well as a vendor, and then as well as a company, what are the penalty, and then what are the things, just how you're going to cover it, right? Just I want to see the breach reporting. As I have asked, like data protection board going to form any committee to the inspection across, all the organization, or like as and when there is a breach comes and reports to the board, then there is an investigation goes saying that like what's the level of control, what's the level of documentations you have it, then based on the quantity. Because then until unless instead of giving 50 crore to here, they can pay it up 5 crore to the the hackers, right? So that concept will come, that aspect. So really just I wanted to see that, because if that has been disclosed, then it is a bigger impact. So the people will try to say that how we can avoid the disclosure so that I can reduce that penalty. This is I'm asking on behalf of all the citizen. So really just love to hear from you, what is a legal requirement for the breach reporting, time frame, mandatory detail format, and when has to report, who has to report, and then only the materialized or maybe the early stages we have to report. Glad to hear from you, Naviji.
See, not reporting a breach itself is one of the reasons for which up to 200 crores penalty can be imposed. Say, having the breach because there was a security failure is one, let us say, omission for which there can be 250 crores. Now, after a breach has happened, not reporting the liability can be for the second offense, which is not reporting. So not reporting is not an option to be exercised by any organization. Even if they tomorrow pay 5 crores to the hacker, they have to still pay this 250 crores or even beyond that to the data protection board. You can always think that board will never come to know. Board can come to know of the breach through several channels. One is, one of the data principals themselves can drop in an email. They are going to actually put up some website or something like that, web page where anybody can report. Okay, they may, I do not know. If I am in their position, I would give reward to people who actually report genuine data breaches. Otherwise, there will be organizations like FDPPI who also may bring it to the notice of the data protection board. So from specific references, data protection board may come to know of it. Media may do it. Or let us say the data ultimately finds a place in the dark web. So some security person will actually report it. It may not come immediately. It may come after 6 months. It may come after 1 year. So if it comes at that time, then if the inquiry is made on the company and the company, the DPB comes to know that they were aware of it, but they did not report, this aspect of fine for not reporting will come in. So I think every organization should ensure that they report the data breach immediately, because it requires as soon as possible report to be made not only to the data protection board but also to the data principal and probably even to the CERT team. Now within 72 hours subsequently, one more report has to be made which is more detailed. Say immediate report will be a short report of just an incident, at which point actually even the company may not know whether the data breach is only imaginary, real, not real, what kind of damages have occurred, they may not know. So once they come to know that there's a provisional data breach, they have to do some internal inquiry, and then they have to report it as a provisional breach to the Data Protection Board. And within 72 hours, they should find out whatever is the reason. If 72 hours is not sufficient, they should ask the Data Protection Board to give more time. They may give more time. And if they report the data breach, then I expect that Data Protection Board is unlikely to consider this company as if it is a criminal. They may not even fine the entire 250 crores. The entire penalty clause says penalty up to so much, up to 50 crores, up to 250 crores. It doesn't say that it has to be 250 crores. And Data Protection Board is not an enemy of the industry, so they will not try to jump and try to collect the maximum penalty. They will be very reasonable. You made a mention that if my turnover is only 1 crore, how will I pay 250 crores? Certainly, Data Protection Board is not going to put 250 crores and make you, let us say, go bankrupt. If it is 1 crore, they may not go beyond 2 lakhs, 3 lakhs, something like that. Okay, enough to actually send a lesson. If there is a repeated data breach and there is recklessness of the organization, then it's a different question. The DPB may think that you are not listening to this. Now, in fact, the law itself provides what is called voluntary undertaking. That is, when an inquiry commences, like plea bargaining in criminal procedures, you can tell the Data Protection Board, I'm sorry, something has happened, I took some steps, but there still something has happened. I would like to correct it. Please give me whatever directions you want to give on how to correct it. And in a voluntary undertaking situation, the Data Protection Board may even waive off the penalty. So let us not think that Data Protection Board is going to actually have these huge penalties. There has been in GDPR penalties for 8,000 crores, 10,000 crores. There I have myself said that these organized supervisory authorities are trying to make it a revenue generation mechanism. Indian DPP is unlikely to do it. Anyway, this money is not going to the Data Protection Board. It is going directly to the Consolidated Fund of India. So it will not help them to even show better performance or something like that. They have to separately seek funds for running DPP from the government, from the budget. So just because they have collected more penalties, they are unlikely to have more funds to spend. So I think that the organizations should act in good faith. They should have a good incident management system, and they try their best to find out if there is a data breach. And if there is a data breach, they have to do the investigation and report it as early as possible. And I think they should take DPB into confidence in this particular thing. They should not think that if I report, something wrong will happen. Even if you don't report today, after a week or 10 days, somewhere it will leak out. The reputation loss is anyway going to occur. You cannot say my reputation loss I am protecting or something like that. So I think the companies need to look at it that way, not try to shortchange this data breach reporting system.
Awesome, Naviji. Really, just we are also looking forward. The Data Protection Board will look in terms of to regulate the law, may not be in terms of towards collecting the the penalty, right? That's the expectation. So some more interesting since already we reached 5-4. Maybe in another few minutes we'll wind up. Who owned this Data Privacy Act, overall DPDP Act? Who owns in this organization? Whether it is, of course, the CEO is complete accountable.
Okay. Now, in the organization, if you are a SDF, the data protection officer is the person who has to own it. CEOs will have to actually give him enough say support so that the DPO can work. In our system, our DGPSI system, we always suggest that there has to be a governance committee. this governance committee should have the stakeholders from the marketing, HR, and other departments, and have a representative from the board, most likely the independent director. I call that as a DPDP governance committee. DPO also will be there. And that board, that particular, it's not a board, it is a I mean, I can say you can
Governance committee.
But that committee will have to own this responsibility, not make one single person called the DPO responsible for everything. So at the top level, it has to be the board, and at the operational level, we suggest that there has to be a distributed responsibility. A number of people in the organization should be having responsibilities within their data processing zone, and that way the entire organization will try its best to ensure that the compliance is possible.
Great. Now, just one more one-liner follow-up questions I have it. Really, this overall DPDP Act, do you think like which sector is more impacted or benefited?
Every sector
Maybe the
is
BFS sector.
there is okay, and see, fintech, health, they are at least better prepared because they know. There are other sectors who had no knowledge of this particular kind of legislation, and the impact, at least it is like in weather. Sometimes we say temperature is so much, but it feels like something else, another 2-3 degrees different. Likewise, these non-sensitive sectors may feel the impact much more than the sensitive sectors, smaller entities. They do not know. The education sector, for example. Now, the NGO sector, okay, they are all company organizations which have no proper understanding, and they will feel the impact much more than a ICICI bank or a HDFC bank. They are all well prepared, even as okay.
Awesome. No, that's true actually. They're all well prepared as well as it's a regulated entity. Already their cybersecurity framework would have regulated on the fundamental stuff. So maybe on top of that, like making horizontal vertical lines will have a lot of insights from there. We can take it forward. It's a couple of interesting questions, Navi and Kushbu. I really just wanted to take it forward. Maybe you can pick up which of the questions you would like to see. The first one, what is the immediate actionable steps for the middle layer in BFC? And because it's, I think the DPDP Act, it's like already RBI have a CSF, and then in fact RBI had released the respective circular also. That will help to ensure that things are taken care. As rightly now we had mentioned, NBFC is regulated by RBI. Already they have a CSF. The CSF, as well as a third-party vendor assessment, also they have a exclusive the guidelines and direction. So that makes amazing the input. And what is the other one? Satish Kumar, what constitute the personal data for NBFC? If it's just PAN, Aadhaar number only, or both? It is considered as both actually, right? Both will cover from end to end. And then there's one more gentleman, IT corporate. I think Kushbu, you can pick up this. As for rule number 4, consent management, need a clarity whether the companies need to set up a consent management platform with a third party or engage with the individual registered consent manager and place them as part of our employment and then outsourcing. Kushbu would like to take this up. You're on a mute. Naviji, just you would like to take this, like more as a consent management.
I've already mentioned this as a misconception. Consent manager cannot be appointed by the data fiduciary. Okay, consent manager is an independent business. He is a trustee for the data principals. Data principals become member of a service offered by the consent manager, and consent manager then offers another service to the data fiduciaries. It is similar to account aggregators, but maybe somewhat slightly different. So you should never look at you appointing a consent manager. You have to only let the consent manager register with the data protection board. The moment data protection board discloses that XYZ has today been granted registration, you should be capable of receiving consents of all his clients through the consent manager. That provision you have to make. There will be an API. It will be an interoperable platform. Without that, they will not get the license at all or the registration at all. So once somebody is registered, they will have to broadcast their API, and you have to implement that API into your page where you collect the consents. Okay.
Perfect, Naviji. And then just one more clarity also, people may look right now, just many organizations, so they are coming as, they are the consent manager. Now, just for till this 11 months, they can start consuming those consent manager, or we can wait till data board approve.
Today, whoever is calling themselves consent managers are people who have some kind of a software for consent management. They are not consent managers as per the legal definition. Don't get misled by that. If their software will be useful to you, you can try, but they are not consent managers, and most of them may not get the registration. You wait until somebody is registered, and you don't need a consent manager mandatorily. You continue to collect consent from data principals from your normal web page where you are collecting. You don't it's not mandatory that you should collect it through consent manager. Maybe after 1 year, nobody may apply for consent managers for another 1 year or 2 years. So we have to continue the way we are doing now without a consent, expecting a consent manager. In your organization, if you want to actually give responsibility to somebody to manage consents, that is an internal position you are creating to make your work easy. For example, in HR department, I may ask one person to take all the consents from the employees and work on that. That is an internal arrangement. That person is not a consent manager. Please do not designate him also as a consent manager. It's a legal term. The word consent manager is a legal term defined under the DPDP Act. Let us not use it loosely. We will call these other software vendors by a different name. You can call something a consent management system, but you don't call that software vendor as a consent manager, or the software itself should not be named as consent manager. It will be misleading, and we should avoid that.
Amazing, amazing. Yeah, that's true. That's a clarity which is required for the next at least 11 months. So that people can choose it, whether it is whatever they have started to engage, they continue to be, or once maybe the data protection board approved, then they can start engaging. So that aspect, just they can plan it actually. And the next interesting question is, what happens if the child forges the consent of the parents? It looks like always in school records, reports card, we sign it, right? I mean, as a parent, looks like it's a parent, it's signed by the student. So that's a question it comes. The parent itself take and then put a consent. Without the parent consent, they give the consent, right? So how do we handle that actually?
The rules say that the data fiduciary shall exercise due diligence. Okay, the word due diligence is an open-ended thing. You have to first of all check whether a person is minor or not, and if sometimes he may simply say, I'm not a minor, so you are misled right from day one, starting point. Then when you ask who is your guardian, he may show one of his friends or somebody like that, one more email address. You send a consent request there and he may give the consent. So there also you may be misled. So when we say verifiable consent, it requires verification that a person is a minor, verification that XYZ is the parental guardian of that particular person, and then take the consent of that person. As of today, there are not many instruments in the marketplace which data fiduciary can rely upon, but Aadhaar for minors does have an element of who is the parent. Okay, minors Aadhaar contains the name of the parent. That is the closest today as an instrument from a government authority which can be relied upon to find out who is the guardian. Say, government is trying to encourage certain DigiLocker kind of organizations to come up with a scheme whereby they are able to confirm whether a person is a minor or not through documents which they must have collected earlier. So there will be some systems coming up before the next a few months, where there will be some entity, which may be a private entity, which may collect some charges, whatever is that, there will be somebody who can verify this minor's age. Then this possibility of a fraud is reduced. Beyond this, if somebody gives misrepresentation, you know that there is a duty cast on data principle, so the duty is not fulfilled. But in the case of a minor, you can do nothing. A person, you cannot punish him, so that you have to live with that kind of an uncertainty.
True, Naviji. And then one more interesting steps is like the major players in India is AWS, Azure, and then GCP. It's all the players are included or not. I think they're absolutely included as possible because they are the data processor. Yeah, Naviji.
Yeah, most of them are data processors. Okay. And there could be some instances where they can be joint data fiduciaries in case the applications are owned and run on the cloud by the cloud service provider. If the cloud service provider only gives storage, then they may call themselves as processors, and data fiduciaries should have their own arrangements by which, before the personal data is dropped on the AWS, they should encrypt it or pseudonymize it. There is no need for them to share identifiable personal data with AWS or Azure or something like that. So let us not blame them. The data fiduciary should have an exit gateway where personal data going into the cloud is actually encrypted or perhaps pseudonymized. And when it is called back for processing, then identify it or perhaps decrypt it. So you run a gateway within your systems, then you will not be worried about what happens in the cloud. Otherwise, once it goes into the cloud, you do not know where it is stored, and there could be various issues. So that is in your hands to correct.
Absolutely, Navji. One more interesting step is how do we deal with Surinder? How do we deal with the customer data which has been collected during marketing campaigns and surveys? So whether it is old data also included as part of the scope, or
Yes.
like from after 1 year, whatever it comes.
This act becoming operative, that is the May 13th, 2027, you have to make an inventory of the existing data, send privacy notice, identify for what purpose you are presently using it, then send an appropriate notice and give a reasonable time for them to accept that notice and give a consent. Otherwise, you have to take a view on purging that data. You cannot continue processing if somebody either withdraws the consent or if he remains quiet, then you can wait for a reasonable time, after which at least you should purge the data. And during this intervening period, when you have sent the notice for a legacy data, you have not received the consent, though the law permits now for a reasonable time you can continue processing, wiser counsels say that it is better not to continue the processing unless you can have a legitimate use kind of argument. If you can show me a document and say that I need to process it and I have the legitimate use or I have got the exemption, then you can continue. Otherwise, you may have to actually delete it sooner or later, not more than in 3 years. 3 years is the limitation period in most of the contractual these things. And in one part of the rules, government also has made a mention in the case of e-commerce companies and social media intermediaries that if the customer is not in contact with you for 3 years, then you have to delete or erase that data by giving a 48-hour notice just before the erasure. The same principle may apply in the case of legacy data for which you don't get response for your consent.
Awesome, Naviji. The one more thing is, if I'm going to start a company in the next year, will it be required to comply DPDP law? When the day starts, you register. I think they have to comply with this, right?
It is your wisdom whether for 6 months you would like to run without being compliant and then rush on the last. It will be another indigo case only. Okay, so it is better you start complaining by design, even when you are planning for the company. So I think anything else, I don't think is a wise move.
Awesome. And then there is like one more interesting question from Ashwati. Like there is a DigiLocker verification. Is it the same as when LinkedIn the verification done through the Aadhaar card and DigiLocker and live photos? Again, they hold our personal data, right? Do you think that is a right way of doing, or is a different way of?
It's it's a misconception concept. The DigiLocker as of today is a repository of documents. I can deposit my driving license, I can deposit my Aadhaar and so on. DigiLocker currently is owned by the ministry. Okay. Now, we have not given them permission to read what is there inside the document which have deposited. For example, my marks card I would have put in, but they are not supposed to read what is my marks. They only know that my SSLC marks card is there. So if there is an entity like an educational institution which is authorized to collect my SSLC marks card, they can actually pull that from the DigiLocker, but they have got the right to read that, because I would have given them the consent for job application or something like that. DigiLocker authorities do not have the permission to read the data. They only have the custody of the document. The new kind of DigiLockers, which this act has rules has made a mention, I think they are the new DigiLocker systems which have to come licensed, and they will be the consent managers who will be taking this data, and then they will also perhaps be acting as like an account aggregator, or perhaps they will have the visibility. So that is a new kind of system. I don't think the existing system fits into this requirement correctly. There are a few gray areas in which I personally feel that the rules are also not properly written. Government, particularly this consent manager thing, even the ministry has tried to go by the account aggregator thought process, which does not apply here. So that I think will have to be sorted out in the next couple of months.
Absolutely. And then now just one more interesting question from Ashwati Menon. Can we expect a reduction or control in marketing calls? Because every day we get a call for the loans and other subscriptions, whatever they wanted to do it, right, for the credit card. Like the people can sue them, or by default the call will get reduced.
If you sue them, you are suing them for the loss which you have suffered, which is my 5 minutes was wasted or something like that. That will not give you any much of a compensation. But you can always drop a complaint to the data protection board, and they may take action against the company which has engaged these marketing agents. And there this 250 crores, etc. may apply, because it is without consent. You are charging them. Now they have to either show where a consent was already obtained, otherwise they will be liable for DPB penalty. So over a period of time, a few persons making a complaint, then these people also, because all of these people are not ordinary marketing calling occurs. It will be an Airtel, it will be a Bajaj Finance or something like that. So they cannot afford to risk the penalties. So I think they will slowly come to a situation where at least they will ask for consent before they do marketing calls. So I think it will get reduced gradually. Your responsibility is to file complaints with the data protection board as much as possible. If you want to claim compensation, you have to go to the Adjudicator and Information Technology Act. That compensation will be only a compensation for the actual loss which you have suffered, which in most of these cases will be nominal. So I don't think it is a great possibility.
Amazing, Noviji. Now we are going to touch close to 2 hours, but it's like really interesting. Still, we are happy to talk more on subsequent our series and discussions. So really, we found, of course, I learned a lot, in terms of concern and purpose, and in terms of the rights for the data principles and the legal responsibility. Of course, the cross data border data transfers and enforcements and liabilities. And as a layman, what I should do, as a data fiduciary, what I have to do, data processor, what I have to do, and all the aspects. Of course, we got to know from the AA side also, like where exactly we have from the AA standpoint as a law, where exactly it stands, or maybe subsequent days or maybe the years, we can see that a dedicated law for the the AA from end to end. Of course, how we can vet both the cybersecurity and then overall data privacy by designs on the early stages itself. And of course, we covered in the wider aspects of in the contracts and vendor management, third party, of course, all the cloud providers, what are the things that they have to ensure on this. It is amazing conversations, and thank you, Navi, Kushbu, and Pavanji, and then as well as Prashant for the wonderful insights. And thank you all the audience for the interesting questions. I think the questions is the one which interacted more, which extracted a lot of information from the leaders. Of course, many more questions still we not answered by considering the time, but we will answer in the subsequent series of session. Naviji, maybe the final input. Of course, cyber security as well as data privacy is everyone responsible. As rightly you mentioned, we should not wait till like how the Indigo crisis was happened, even though law was amended like 2 years before, and we should not wait till the end. Actually, that is like a perfect example that you have given. We can start addressing from the day one, so that the last day we may not be in the crisis situation. So, what do you know, Vijay? The final note to all the readers.
See, people like us are trying to tell that this compliance should start much before the day when the penalties will come. And in fact, this law as it is today is considered as due diligence under Information Technology Act. And therefore, legally speaking, I say that this is more or less effective even today. So I expect most of the organizations to take it seriously and start working. Normally, this compliance takes 6 to 9 months in any organization. Nobody can do it before that. So if 1.5 years is given, it is all the time is required for creating this compliance system, testing and other things. So I feel that there is no time to lose. Maybe you can wait until the new year, and maybe January you should start working on that. There are people who are already assisting the companies, and I feel that there should be no complacency in this. Thank you.
Awesome, Punaviji. Thank you so much, and thank you, leader. Thank you so much for listening and for putting it so very interesting questions. Looking forward on upcoming series of CIO on DPDP actions and then the impact. Thanks a lot. Have a wonderful day ahead. See you all on the next session.
Thank
See you,
you.
Vijay.
Yeah.
Thank you.